We're going to be hearing from Richard Leo next. Dr. Leo is the Hamill Family Chair in Law and Social Psychology and Professor and Dean's Circle Research Scholar at the University of San Francisco School of Law. He's also a fellow in the Institute for Legal Research at the University of California, Berkeley School of Law. He previously taught as a tenured professor of psychology and criminology at University of California, Irvine, and a professor of sociology and adjunct professor of law at the University of Colorado in Boulder. Dr. Leo, as we now know, is one of the leading experts in the world on police interrogation practices, psychological coercion, false confessions, and the wrongful conviction of the innocent. Dr. Leo has authored more than 100 articles in leading scientific and legal journals, as well as several books, including Police Interrogation and American Justice, was one of his most widely read and widely cited works. And he has a book coming out next year entitled The Innocence Revolution, A Popular History of the American Discovery of the Wrongly Convicted. Dr. Leo's background, he received his law degree from Berkeley and a PhD from Berkeley as well. I would list the journals that he's published in, but we'd be here for probably 20 minutes going through them. Needless to say, it's a wide variety of law journals, criminology, law, and psychiatry journals. So join me in welcoming Richard Leo. Thanks.
Thank you, David, for that introduction, and thank everybody. I thank everybody for being here. I know 3 hours straight is a long time. I'll try to finish early. I also feel honored to be on this distinguished panel and at this distinguished symposium. So I liked Gary's organization. If I had to do this over again, I would do Gary's organization. How do we know it's a problem? What does science tell us? And what are the possible reforms? I'll more or less follow that, skipping over some of my stuff. We know that false confessions occur. They've been studied for a long time. We've got a good scientific literature that I'll talk something about. We also have lots of cases and case studies. So this is the question that Gary began with. How do we know there's a problem? How do we document false confessions? And I want to talk about the databases that Peter and Gary have spoken about, and also about what criminologists might do. This is an understudied area for criminology. So we've got real-world data and we've got laboratory data. We could slice it 2 or 3 ways depending on how we classify, survey data, etc. So focusing on what I call real-world data, which is tend to be my own focus, but I'm just one small part of a much broader field. We've got lots of individual case studies of documented false confessions. In many of those cases, some of them Innocence Project cases, we have 2, 3, 4, 5, 6. The Beatrice 6 case, I don't know if this has a point, but the down on the far right, this is 6 people. I think there's more now. There's a case in Chicago where there's 7 false confessions. So this is crazy. Just like the number of eyewitnesses who can be wrong, just like the number of forensic dentists who can be wrong, there can be multiple false confession cases. My colleagues Richard Offshee, Steve Drizzen, and I have aggregated some of these false confessions, looking at 60, 125, and now we're working on a study, different co-authors of 200. Proven false confessions, we'll talk about that in a second, and trying to look at patterns across these cases. Now, of course, when you aggregate cases and look for patterns, it's a correlational study. It's not the same as doing something in a laboratory. You get more external validity, but less internal validity. So we've focused on these cases, proven false confession cases, to avoid what sometimes happens, what sometimes lawyers, prosecutors, former prosecutors want to do when they see a large-scale study of false confessions and say, well, you're wrong about 3 of those, so we can just ignore the other 197. You get this back and forth about the 3 that we don't think we're wrong about, but we can't actually prove the negative. So these proven false confessions, this category of proven false confession that Richard Offshe and I coined in 1998, is an attempt to say we know with a near or absolute level of certainty that this person could not have committed the crime. This is even different from an exoneration because many of these people were not exonerated because they weren't convicted. Many of the people who were exonerated, not by DNA, but exonerated legally, since an exoneration is a legal category, you can't prove their innocence, right? So this may be the most conservative criteria for identifying false confessions. No crime occurred. One of the slides I showed multiple false confessions had Medell Banks. He and I believe his former wife and sister were all convicted of murdering a baby that was never born. We have cases, not many, where the murder victim does show up alive after the confession. Physical impossibility is where the person could not have committed the crime. And the classic example I think Peter gave of a non-false confession case was Mr. Gates on the rape, right? They dropped the rape because Mr. Gates was in jail at the time the rape occurred, if I heard that right. So too in many proven false confession cases. The person is somewhere else documented on videotape by a bank camera or in a prison or jail or in another country. The scientific exclusion category is mostly the DNA cases, dispositive exclusion of the person as the perpetrator. And then the most common of the four ways of proving a confession false to a near or absolute level of certainty would be where the true perpetrator is identified. That happens a lot in these cases. And of course, these are not mutually exclusive. So you could have several of these occurring at the same time. So this is how we've documented false confessions in the real world, apart from the databases where there's some overlap, but the DNA exoneration databases that Gary and Peter have talked about, a small percentage of these are false confessions, depending on how you count, 15 to 25%. If you count the way Brandon Garrett does, closer to 15%. Just the people falsely confessing. If you count the way the Innocence Project does, cases involving people who falsely confess. So I think, for example, the Fort Heights four individuals, one or two confess. All four cases are coded as involving a false confession. There's not a right or wrong way to do this. It's just a different way of looking at the data. All four people were convicted in relation to those false confessions, even though only two had falsely confessed, or one had falsely confessed, two had made incriminating statements. If I'm remembering correctly, I may not be. Anyway, so this is a range looking at this very special, as Peter put it, data set of the DNA exonerations. The National Registry of Exonerations has been discussed, and this was started by Sam Gross at the University of Michigan and Rob Warden, then at Northwestern. So they have, as Peter pointed out, over 1,700 exonerations. They go back to 1989, the first year of DNA exonerations. And they too are under-inclusive. They have what I would characterize, not everybody, including Sam Gross, might agree with me, but I would characterize as more legal criteria as opposed to factual criteria. I don't think anybody reasonable has challenged a DNA exoneration. Sure, some of the former prosecutors and police officers, including in the famous Central Park jogger case, whereas in the National Registry, Sam Gross will say, yeah, we've got some guilty people. We think it's a very small percentage. We've got some guilty people. We leave out a lot of innocent people, including some who by any reasonable stretch would have been exonerated by DNA, like Carrie Max Cook, for example, who has to be innocent, but took a plea deal, like many people have done, to get out of prison after being wrongfully convicted, in his case, a couple times, and about to be wrongfully convicted a third time, and so not officially, in a legal sense, exonerated. And the 224 out of 1773 is roughly 15%. It's a little bit less than that. And the National Registry is a searchable data set, and if you go to the other way of counting false confessions, cases in which somebody who has been convicted may not have themselves falsely confessed, but a co-defendant falsely confessed. There was a false confession in that case. The number goes up to close to 20%. So the two databases track each other. And I want to take this moment to make a plug for criminology. So I was a professor at UC Irvine for a decade in criminology. And like Simon Fraser, UC Irvine has a leading criminology department. And I left for a law school in San Francisco for purely personal reasons, had nothing to do with Irvine, which I still miss and love. And when I was there, I could not get graduate students interested in studying police interrogation and false confessions. I think what Peter said is actually right. People study where the money is, and one of my colleagues who also went on to law school, then colleague, the famous professor of criminology, Joan Peter Celia, studied things infinitely less interesting than false confessions and the wrongful conviction of the innocent, and she always got the cream of the crop of the graduate students, and the reason was because she had tons of money. So let me say this. The study of false confessions and how false confessions contribute to wrongful convictions is almost entirely dominated by experimental psychologists. And that is a good thing in many ways, because the science is the foundation, the experimental science, and the experimental scientists have done great work. But this is an area that is much harder to model than the even better experimental work that's been done for longer in eyewitness misidentification or mistaken identification. And so it's an area that is in many ways riper for real world or qualitative, it doesn't have to be qualitative, systematic empirical study by criminologists. Aspiring criminologists who want to study false confessions and how they work in the criminal justice system and what we don't know or could know better, or how that relates to the experimental data, are in a much better position now to study this than they were even 10 years ago when I left UC Irvine, because since then, if I have this right, I think I do, the Innocence Project's database has gone online to some extent. I think the firm Winston & Strawn has spent some money, and you can apply to the Innocence Project to get access to materials that they have that are available, that can be searched online and downloaded, actual case files and case materials. Peter can correct me if I'm wrong. Has to go through an application process. There is the National Registry of Exonerations that some of us think have been with us forever, but it's actually less than 5 years old. And it too has a searchable database, and you can write to Sam Gross and make a proposal, and you can get data to study this. And so there is the opportunity for criminologists to empirically study it within the tradition of criminology, which is rich in studies of policing in the criminal justice system that don't exist in experimental psychology, that I think would add convergent insights and deepen in some ways and push in other directions for research questions. Okay, we do not know how frequently false confessions occur. It may be the wrong question. This is the tip of the iceberg. We've heard that 5 to 10% of the cases involve the DNA. 5% of cases have DNA evidence that go to trial. We believe that the documented false confessions, whether it's in the DNA database, the National Registry, or our proven false confessions, is just has to be a small number of the much larger, much greater number of false confessions out there. One of the things that we've studied before we get to the contributing factors is the impact of confession evidence and how prejudicial it is. And one reason to study confessions is because they almost always lead to wrongful convictions. One of the things my colleagues and I have done is surveys of why people assume confession evidence must be true, or is almost always true, at least in America. And the surveys have become increasingly sophisticated. We've done college undergraduates. We've paid marketing firms to get demographic, to go into communities and get jury-eligible adults. One study that I did with Iris Bland and Gitlin, we had real jurors in a Santa Ana courthouse. And these surveys show that people understand interrogation methods can be coercive and can lead to confessions, but don't understand that they can and often do lead to false confessions, and don't make that link, and tend to think that they themselves would not falsely confess. Why would others? It's irrational, it's self-destructive, it's against self-interest, it makes no sense. And there is what social psychologists call the fundamental attribution error, which is the tendency to attribute to personality the failures of others, as opposed to ourselves attributing our own failures to circumstances, and not to fully appreciate the situation, the environment that produces the confession. And so in the studies of the consequences of false confessions, we see that, and I'm not going to go through this slide, every part of it. Oh, I do have a... when you have confession evidence, the police are immediately biased in the sense that they close cases, they don't look at alternative suspects, they refuse to admit error. Prosecutors tend to charge more aggressively, make the confession a centerpiece of their case. Defense attorneys tend to presume the guilt and pressure their clients to plead. I'm sure Peter could tell stories where the Innocence Project has called up or an Innocence Project has called up a defense attorney, as in the case of Chris Ochoa. And the defense attorneys say, "You're wasting your time. He's guilty. Why are you calling us? Focus on real false confession or real wrongful conviction cases." Of course, Chris Ochoa, one of the early famous DNA exonerations, went on to become a lawyer, not a criminal defense lawyer, but stone cold innocent. Okay, juries more likely to convict, judges more likely to sentence higher. I liked Peter's comment about scientifically illiterate lawyers and judges. I think often get off in this whole. I've been studying this as long as many people here, or almost as long. Judges always get off. For some reason, in the study of wrongful conviction, we always blame the police, we blame the prosecutors, we sometimes blame defense attorneys, we blame the legal system. Judges always get off. They are never seen as complicit in these wrongful convictions. In fact, in my wrongful conviction seminar, occasionally people will write papers about judges. There's no literature on how judges contribute to wrongful convictions. I hope in 10 years that's going to change, but I'm not sure how it would. And then, of course, the American system of criminal justice is based on procedural error, as are many Anglo-American systems, not on substantive errors. That's changed a little bit in terms of post-conviction and habeas in the last decade or so. But it's a system that once you have the confession, it's almost like the train has left the station, and we have this fiction of harmless error analysis, which is used to justify wrongful convictions in America. So the confession itself is a very damaging and biasing piece of evidence, even when it is false. And I want to just point out these studies of wrongful convictions. One startling statistic that seems to keep going up, although I've got a study in progress where I don't know what the number is going to be. Okay, so we looked at 60 false confessions in 1998, 125 in 2004. My colleague John Gould and I did a study of near misses in wrongful convictions, had 400 or 500 cases, 110 of which were false confessions. And then Steve Drizzen and I and a couple of others are currently looking at a 200-plus study of proven false confessions. So in these studies, one of the questions is, what are the consequences of the false confession? And what you see in these studies is anywhere from a third to a half of the confessions filter out before going to trial. Some of them, but a minority of those, are plea bargains. Most of them are dismissed or suppressed or somehow fall out, right? So you have maybe a half to two-thirds that result in conviction. Of those cases, if I have that right, no, one-third to a half that result in conviction. Of those cases, this is what the statistic here, I should have done a better table. The statistic here is 73% of those cases resulted in conviction, 81% of those cases resulted in conviction, 88%, and now 93%. This Leo et al. Study that I never seem to be able to write up, of 200 plus, are new proven false confession cases since the Drizzen and Leo study of 125 published in 2004. So these are amazing cases. These are cases where the person was interrogated for 12 hours. These are cases where there was no evidence other than the confession and mistaken or misconstrued ambiguous evidence, circumstantial evidence. These are cases where the person screamed from the rooftops from the beginning they were innocent, right? These were cases where they alleged coercion, and yet they get convicted in very high numbers. So this just goes to how prejudicial confession evidence is. And this is something that's very old. I know Colorado v. Connelly is one of Peter's and mine's favorite cases. One of the missions of, I think, Peter's long held missions is to get this case overruled de facto. The courts are just repeating age-old, the Supreme Court here, age-old conventional wisdom that lawyers have known for centuries, that once the real trial happens in the interrogation room. Once you have a confession, it's almost always over. Now, I want to move to this issue of causes, or maybe that's not the right word, contributing factors. One way I think about this is the sequence of errors, and I think this is a more criminological way of thinking about this than some others who have other ways of thinking about it that may be better or different, who study this. This is a very interdisciplinary field, is the sequence of errors that lead to a confession that is false and almost always leads to a wrongful conviction when the case goes to trial, but is false, it looks true and leads to a wrongful conviction. So let's talk about these three errors, what I call misclassification, coercion, and contamination. Police are trained to read body language, to be they're led to think, they're misled to think that they can decipher whether or not someone is lying about committing the crime or not based on their demeanor, their voice, even how they're sitting. If you look at, even in this day and age, police interrogation training manuals, they have pictures of people slouching in their chairs in ways that suggest guilt and other ways that suggest innocence. In a way, this is really like the forensic science stuff that Peter talked about. It's an extension of that. It's cop folklore that is concretized into this mythology about you can tell innocence from guilty based on these intuitions. And of course, there's no science behind it, and the existing science contradicts it. Most of the and there is a good experimental literature on how well we can read or interpret demeanor evidence for some ground truth proposition. One study, a famous study by Ekman and O'Sullivan, shows that all these groups who are lie catchers, broadly speaking, except maybe college students, though maybe they are too, get it right typically about 54% of the time, a little bit higher in this group, but not much higher. With the outlier of the Secret Service, nobody knows why they scored at 64%, although to my knowledge that has not been replicated. But the findings more generally have that about around 45 to 60% of the time when you do controlled experimental studies and you show people videotapes, people get it right based on demeanor, body language analysis, and there's studies training people in the Reed method of interrogation, cops, for students. It all falls in that range. Now this reminds me, before I get to coercion, of what Gary said, which I've always been taken with and thought about in a slightly different way before I first heard him say it in 2006, about the reasonable suspicion requirement before you put somebody in the inherent jeopardy of a lineup. To put somebody in an interrogation room is to put them in inherent jeopardy for other reasons. And in America, the Reed method I think is more controversial here in Canada. In America, interrogation is guilt presumptive by design. Police are trained. Only interrogate after you've concluded they're guilty. The American method of interrogation, the Reed method, is get them to confess. Right? You accuse them, talk about this in the coercion section, but the whole goal is to get the confession, not the truth, because to the police it's the same thing. They know they're guilty, the goal is to get the confession. It's driven by what psychologists call confirmation bias and tunnel vision. So the reason I'm reminded about what Gary says is because, and here we go to criminology, the studies of police, the rich literature in criminology studying police, mostly ethnographies of street police, not detectives. Police believe themselves, at least in America, to have this sixth sense that they are divine interpreters of the truth because they are so street smart, and that their heuristic, though they wouldn't use that word, allows them to discriminate between liars and non-liars. And if you talk to them, they talk this way about how they know somebody's guilty with such confidence, right? And so what Gary was talking about, these are essentially hunches, gut hunches. Police routinely make gut hunches. Now, sometimes there's more than that. I have recently said, because I think the Miranda warnings are largely worthless in America, and because there's a former prosecutor, former federal judge in America, a bit of a gadfly, a little bit crazy, who likes to say, but wouldn't you trade Miranda for videotaping? Why can't we just get rid of Miranda, as if anybody else is asking that question, and have videotaping? I would trade Miranda for videotaping, but more recently, I've suggested that police get master's degrees, and I would trade that for Miranda, because I think if police were better educated, they wouldn't act on their gut hunches. And then even more recently than that, I've thought just a class on Tversky and Kahneman and the kinds of errors that people make, cognitive errors, reasoning errors, might reduce false confessions more than Miranda, which doesn't for the most part. And Gary had made the point, very provocative comment, which if there had been time, I would have asked the question. Gary had made the point in Eyewitness that if you had a reasonable suspicion requirement, assuming that's meaningful, in America it's become so watered down. There's a recent Supreme Court case in which Clarence Thomas wrote the majority opinion. Somebody drives off the road allegedly in a dangerous manner, and 5 members of the United States Supreme Court says that gave the police reasonable suspicion to believe that the person who drove off the road dangerously was driving drunk, which is completely nuts from a statistical perspective. But anyway, so Gary had made the provocative comment that if you implemented that reform, it would take care of most of the problem. In other words, if I'm getting this right, that could be, because of the base rate issue, the most serious way to prevent erroneous eyewitness identifications. And I've thought the same thing in the interrogation context, that if you worked on this misclassification error, that you would reduce false confessions. Because if you just think about it as a thought experiment, if 999 out of every 1,000 people interrogated were guilty versus, say, 500 or 300 or 750, it doesn't matter how coercive the interrogation is, you're going to reduce the false confession rate, because they're not going to be there to be taken. Okay, so every time you get a false confession, you have that misclassification. An innocent person is in a process designed for the guilty, designed to get an incriminating statement from the guilty. The second error is then the series of methods that, or vulnerabilities that lead to the false confession. And here, because of time, I'm not going to go into as much depth as I might otherwise. This is a police training manual from the Los Angeles Police Department, and it says it better than I could. Right here on the vaguely underlined part, which I can't seem to. Here it is. It, meaning police interrogation, operates on the principle: you did it, we know you did it, we have overwhelming evidence to prove you did it, but the reason makes a difference, so why don't you tell me about it? Essentially, all American interrogation, all Reed interrogation, which they've exported throughout the world, is about convincing somebody that they're caught with absolute certainty, the evidence which they can lie about in America and make up and fabricate. You did it, we know you did it, we're not hearing anything else. And then to induce them through promises, threats, the functional equivalent of promises, through appeals, through minimization, I'll talk about that in a moment, to think that in that moment they are better off confessing, given the range of options that are available to them. Okay, so I can't get this to advance beyond this. Let me see if I can. Is there another way to do this? Oh, okay, very good. So I'm going to skip past this. I've already talked about this. Let me talk about some of the laboratory studies. Actually, let me back up if I can figure out how to do that. I can't figure out how to do that. Okay, so what I wanted to mention here, I guess it's going to be later in the talk too, but let me just highlight it here. In terms of inducing false confessions, lots of interrogations involve threats and promises that are implied by context. Police are trained to minimize the consequences of what will occur if a suspect confesses, to get them to admit to an accident or self-defense or provocation, to get them to think that what they admit to is not a crime or will be a lower level crime, to get them to think that the consequences that follow, everyone will understand. They won't go to jail, or they won't go to prison, they'll get counseling or help, or the officer or the prosecutor or the judge or the jury will be able to help them minimize the damage of their case. And police are trained in what they call themes or scenarios that minimize. This is a book put out by Reed and Associates that has 1,600 so-called themes or scenarios that minimize for all the different types of crime, given some examples up there. A lot of what goes on in interrogation is changing the perceptions of a suspect to think that essentially, the Reed manual in 1986 had an appendix that explained the psychology as best they could do it. That appendix came out in the subsequent edition, but they essentially said to get somebody to confess, you want to increase their anxiety and pressure them, essentially coerce them, and decrease their perception of the consequences. And that's their psychology of eliciting true confessions, and it works for false confessions as well. Okay, so I've been talking earlier about the field studies, the real-world studies, proven false confessions. There's this rich literature eliciting or inducing false confessions in the laboratory, which of course has the benefit of controlled conditions, random assignment, and you can parse out causation, which strictly speaking you can never really do in field studies, though you could do under the right assumptions, statistical analysis with some level of confidence in field studies. Okay, so one field study I want to talk about, experimental study rather, which has been replicated, is the Russano Et al. Study. This is a brilliant paradigm, what psychologists call paradigms, which is different than the use of that word in other social sciences, where people were induced to cheat, and some did not cheat, in an undergraduate environment where cheating carried serious consequences. And so what you had were, and then they were interrogated using Reed-based interrogation techniques, and some people had not cheated, and others had cheated, and there were false confessions induced as well as true confessions. And what the Russano team and Gary's colleague Chris Meisner, who was involved, and Professor Russano's advisor at the time, wanted to look at was the diagnosticity of these techniques. In other words, how likely was a particular technique to lead to a true versus a false confession? I think we all want the same thing, which is in interrogations, a higher level of true and a lower level of false information, confessions, right? So a good technique would be one that's more diagnostic, right? That leads to, let's say, 100 true confessions for every one false confession. And a bad technique would be one that led to a low diagnosticity ratio or a higher level of false to true, say in the opposite direction, 10-1 or even 50-50 presumably would be pretty bad. And so they looked at particular techniques and their diagnosticity ratio. In this study, minimizing the consequences or the seriousness of of the offense or what will happen to the suspect, and you see no tactic. I recently spoke to Melissa Russano. This really wasn't no tactic. She regrets how she wrote the study up. It really was a confrontation, but 7.67, that's good, right? That means you get a higher true to false confession rate. Offering somebody a deal, it goes down. You offer somebody minimization, make them think the consequences are not that severe. You add minimization to deal, you get the lowest one. Fadia Narchet and her colleagues did some of the same techniques, categorized them a little bit differently. They too look at the diagnosticity ratio. Maximization, though a weird term, is the opposite of minimization, exaggerating the consequences. And this is very common in interrogation, where you try to get somebody to think if they confess, maybe they'll go free, or they can fight their case later, or it'll just be about a misdemeanor, not a felony, or they have mental health treatment available to them, or they won't be the one bearing the majority of the conviction, their co-defendant or someone else will, as opposed to if they don't confess, it's first-degree intentional homicide. Maybe they talk about the prison sentences or the range of prison sentences, right? And then in this study, they looked at combining where there was maximization and minimization. The terms aren't as important here as the idea that experimentally we can study whether some techniques are more or less diagnostic, and using that we can make recommendations about which techniques would be better to use or worse. And the most obvious one in the United States is the technique of false evidence, which in this literature has been identified as a risk factor. So in this literature, mostly by experimental psychologists, right, we talk about which techniques are more likely to or increase the risk of leading to false relative to true confessions. And in a relatively recent review, these techniques were identified: lengthy interrogation, the false evidence ploys, the minimization, and implied threats and promises. So you would, if you wanted to target which techniques we should try to not allow police to use or scrutinize more carefully, if we took, which we don't, I think, the experimental literature more seriously in America, we would try to limit these techniques or scrutinize them more carefully. If you look at the other side of the equation, and again, this is all under the rubric of coercion error, how do you get a confession from an innocent person once they've been misclassified and put into a process designed for the guilty? We also look at individual risk factors, or the types of individuals who are more prone by their very nature, regardless of the coerciveness of the interrogation, to make or agree to a false confession. And there are three groups here, and the group that's been studied the most are juvenile false confessors. And there's case after case, including the famous Central Park jogger case in the United States, where juveniles, in that case, I believe they were all aged 14 to 16, have made false confessions. We know that the known universe, which of course is just a fraction of the real universe of false confessors and may not even be representative of that universe, is disproportionately represented by juveniles relative to their numbers in the population. There's lots of reasons for that, having to do with their psychosocial immaturity, their impulsive decision-making, their lower threshold for interpersonal stress, their focus on the moment, their gullibility. There's a very rich literature on that explaining why juveniles are more vulnerable. We also know that the mentally handicapped are more vulnerable, people with low IQs. The 70 IQ is artificial, to be mentally retarded or developmentally delayed in the United States. IQ is a continuum. We know there's a whole host of cognitive things that go along with subnormal cognitive functioning, or personality traits, ways of coping, ways of adjusting, that make those individuals more likely to make or agree to a false confession. We also know, although it's less studied than the other two, that people with mental illness, reality monitoring disorders, are more prone to make or agree to false confessions. And so what you get in those groups, I'm sorry to back up so much, what you get in those groups then are individuals who, when subjected to coercive interrogations, are far more likely to make or agree to false confessions. Interrogations involving threats, promises, lengthy interrogations, than are normal individuals. Okay, so you've got a misclassification error. The police didn't intend to get a false confession. You've got coercion, or the use of techniques that increase the risk on individuals sometimes, but more than not, let me back up. More than 50% of the individuals in our proven false confession studies don't have these individual vulnerabilities, right? So most false confessions that have been documented are by mentally normal adults. Okay, so you've got a false confession from an innocent person. Now you've got the problem of contamination. This may be the most insidious of all. What is contamination? It's the leaking or disclosing of non-public facts to the suspect, which then get parroted back included into the confession. Richard Offshee and I studied this in the 1990s, but Brandon Garrett really has done the best work and the most recent work on this using the DNA database. And the problem of contamination is not just feeding the facts, but it's also scripting the narrative. Police pressure suspects to give a narrative, once they've broken them into making the admission, the narrative account that includes a motive, an explanation, and the crime scene details. The police want the confession to be plausible, which of course increases the likelihood of the confession to lead to a wrongful conviction when presented before a jury, especially when there is no videotape. So it makes false confessions appear authentic because they are detailed with case facts that only the true perpetrator allegedly knew, and that representation is being made to the jury when in fact the police knew those true facts and fed them to the suspect, and it's not just a detailed confession, but it's a narrative confession. So Brandon Garrett's study of the DNA cases, he found in his first study of the first 300 DNA exonerations, 95% of the false confessions involved contamination. He then did another study of the next 50, published in the University of Virginia Law Review, the first one in Stanford. He found 91%. I think those numbers might actually be low, because when I talked to Brandon, he talked about how he had to get the trial transcripts, and in some of the cases he couldn't get those, and so where he coded no contamination, he couldn't find it. It didn't mean that there wasn't any, because in every single one of the interrogations in the Stanford study, there was no fully recorded interrogation, and only one of the interrogations of the false confessor DNA exonerees in the Virginia study had a fully videotaped interrogation, recorded interrogation. So these are almost exclusively interrogations that lack a record. Okay, so one of my favorite cases, Peter got me involved in this a long, long time ago. To illustrate this point, the Innocence Project did great work, Peter did great work, is the case of Bruce Gottschalk, convicted of raping 2 women in an apartment complex in Pennsylvania that he had never set foot in. And I believe the Innocence Project, it took 7 years to get the DNA before he could test it. So he spent 15 years in prison for these rapes before being exonerated. And I think anybody in this room would have convicted him in a heartbeat if you had sat on that jury, myself included. The kinds of details that were in that confession would have made you think, there's no way this guy couldn't have done it. The assailant had been outside the bedroom window watching the victim. The victim had been reading a magazine while lying in bed. There was a light next to her bed which was allowing the assailant to see in, but this is the one that just kills me. That prior to having sex, the assailant removed the victim's tampon and tossed it to the side. How could anybody possibly know that fact who wasn't involved in the crime? Well, of course, they would have had to have known the fact if they were involved in the crime, but the police knew that fact, and it made its way into Bruce Gottschalk's confession. Okay, so let me just summarize here. I'm almost done. So the errors that you get in the false confessions that lead to wrongful convictions are misclassification, lots of things to study there, coercion and individual vulnerabilities. Once the innocent misclassified person is subjected to the guilt presumptive interrogation, and then once the confession is given, it's not really a confession, right? It's an admission. I did it. That's not a confession. A confession is a narrative story that explains how and why you did it, that has the qualities of a story that persuade, but can be false, that is contaminated and scripted. There are finally, and then I'll just highlight some policy reforms, but I won't go into them. There are 3 different types of false confessions that involve these errors. Actually, 2 of them do. The voluntary false confession is when innocent people, for typically psychological reasons, confess to crimes not as a result of police interrogation, but confess to high-profile crimes. We see this in many of them. Perhaps the most recent, Mark David Carr in the John Benet Ramsey case. He was innocent. He had mental health issues. What we call compliant false confessions, where people confess to put an end to the interrogation, knowing that they are innocent. This is John McCain in Vietnam, right? He was physically coerced and falsely confessed, and when asked to give details, made up names. When asked how he made up the names, he just gave the front line of the Green Bay Packers. This is Chris Ochoa, who I mentioned earlier. These are other individuals exculpated by DNA. Or not. Ted Bradford is one of the DNA exonerations from the Washington Innocence Project. I could talk more about these others, but I won't. People who were interrogated, coerced, made false confessions, could not bear the stress and coercion of the interrogation, knowingly falsely confessed. The more troubling type, I have Persuaded up here, some researchers called it internalized, are individuals who were broken down and came to think they committed the crime despite having no memory of doing so. Peter Riley in the 1970s, being the most famous, came to believe he must have murdered his mother, who was found dead. It turned out some years later that it was discovered that it was physically impossible for him to have done the crime because of where he was at and the inability for him to have gotten to the crime scene in time. Martin Tankleff, a New York case, came to believe that he falsely killed his parents who had been murdered brutally. The false evidence ploy in that case was the interrogator saying that his father had come out of the coma, and he had been in a coma when he was found brutally stabbed and beaten that morning by Marty Tankleff, had come out of a coma and said, "You did it." And Tankleff came to believe that he did do it, and it took many years for him to, after being convicted, to get exonerated. Okay, there's not enough time for me to go into these, but I'm just gonna flag them. This is how I think about possible reforms. Okay, so mandatory electronic recording, of course, creates that record, so we know whether there was coercion, and perhaps more importantly, whether there was contamination. The most important, the most widely advocated reform, for a lot of reasons. Police love it when they have it, so do prosecutors. It's a deterrent, but more than anything else, it creates a documentation, a record from which we can all evaluate whether or not certain bad things did or did not occur. Improve police training. You know, if they got a little Kaversky and Toneman, I think it could go a long way, although we tend to think of police training as learning more about wrongful convictions, and that's important too, of course. Changing the law. This is where law professors get hung up, and in particular in regulating interrogation techniques. So a lot of the law review dialogue is about that. Let's not let them do this, let's let them do that. I could have put reasonable suspicion here, which would be pre-interrogation selection procedures. Maybe this is just as well. So before you let somebody get into the jeopardy of an interrogation, what sort of scrutiny do you have? And then the regulating the reliability of confession evidence. Peter and I have pushed very hard for pretrial reliability hearings, where defense lawyers use the law of evidence, not constitutional law, to evaluate, that they can use that too, but in this context, to evaluate the reliability of, or to argue for the unreliability of confession statements whose probative value is outweighed by their risk of prejudice, and have it excluded on those grounds as opposed to procedural voluntariness or Miranda grounds. And then you've got some people advocating for special protections for the vulnerable. I'm not such a big fan of this. Usually when you get parents in interrogation rooms, they just become cops and pressure their kids to confess. Expert witness testimony, I've done a fair amount of this. I'm not a big fan of this either, or cautionary jury instructions. As a systemic reform, because my thinking on this, which I think is articulated very well, it's not original to me, in Dan Simon's book, In Doubt, is that if you want to prevent wrongful convictions, you got to start early in the police investigation. Otherwise, it snowballs and develops. And if you wait until cautionary jury instructions or expert witness testimony or more of the back-end solutions, it's already gotten out of control. You're less likely to prevent it. Our adjudicatory procedures are not really well suited to the task of separating innocent from guilty, or not as well suited as we think they are. We really need to focus on the investigatory procedures and stem the wrongful convictions, including the false confessions, early on. Thank you very much. I hope I took my time.
Questions for Richard?
Everyone's very tired if there are no questions. I understand.
Let's ask one quickly. How do you define confession for the purpose of your studies?
Right. So the way we would define a confession would be, we use the term confession really in two senses, with a small c and a big C. So the small c would be a statement, I did it, plus a narrative explanation of how or why you did it. That would be a confession with a small c. The big C confession is an umbrella term that would be anything from an incriminating statement, any statement from which one can infer the person might have been involved in the crime or have some knowledge of the crime, to an admission further along the continuum, I did it, but not a narrative explanation, to the small c confession, I did it, here's how and why I did it.
Because would you agree that statements made by an accused, whether or not they contain admissions, can greatly increase the likelihood of conviction and be false?
Yes,
right.
yes. So it would be better
broader than you.
Yes, it would be better to talk about false incriminating statements than false confessions. And one of the interesting things about these persuaded false confessions, I had a picture of Gary Gallagher up there, spent 2 years on death row in Illinois for murdering his parents. Turned out that they had a motorcycle parts shop, I believe, and it turned out an undercover federal investigation captured the individuals who had murdered his parents, and he was set free, a proven false confession. He was interrogated for like 18 hours, came to say that he must have killed his parents in a blackout. They convinced him he failed a polygraph. If he were here right now, he would say, he'd be mad at me, as he was at the 1998 Northwestern conference when we were on the same panel. He'd say, I didn't confess. Why are you calling me a false confession? I never made a confession. A lot of those persuaded false confessors, confession is I must have, I could have, I probably did, I may have, and then it gets concretized into what is called, perhaps misleadingly, a confession, right? So I would say any incriminating statement, it's all the same. It's essentially coerced or induced testimonial, self-incriminating testimonial evidence.
Can you hear me? I'm wondering, some of the reforms that you suggested require, it seems to me, videotaping of the interrogation. It would be hard to evaluate the confession without some background information on what led to the confession. So my question is this, twofold really. How common is it for police forces to videotape the interrogation? And how might that process be sort of encouraged among those departments that aren't currently doing it?
So your first point is very true. Peter and I wrote an article for the Temple, with a couple co-authors, the Temple Law Review, and we're talking about pretrial reliability hearings, and I think we had a separate section for if the interrogation was recorded versus not, that you needed a higher level of scrutiny when they're unrecorded. So to really do an effective pretrial reliability hearing, you need the record to figure out where the contamination did or didn't occur. We don't know what percentage of police record interrogations, but we know that they are required in 20 states to record some or all of their interrogations in the 20 of 50 states in the United States, and that hundreds of departments in other states do so voluntarily. So there's quite a movement and momentum for voluntary and non-voluntary recording of police interrogations. In my own state, California, police are required in juvenile homicide cases to record interrogations and in nothing else. And the guru of recording interrogations, Tom Sullivan, a former federal prosecutor of some repute and a partner at Jenner & Block, the law firm in Chicago, Chicago-based, has written the most about this. And his view is, if you can just get them to record a little, then you should do it, because they will love it. Once they start recording, they will see the benefits of this, and they'll want to record everything. And that's how you get them to do it. That has not, to my knowledge, been the experience in California. I think recording is inevitable, and they are so worried. I've seen this time and time again. I'm sure Peter has too. When there's public committees or commentary, the cops are always talking about exigent circumstances. What if we have the guy in the back of the squad car confessing to us? We don't have the tape there. I think to get them to do it, first of all, the departments that do it do love it. Get cops from departments who do it to talk to the cops at the departments who don't, and craft legislation that has exigent circumstances, exceptions, and reasonable presumptions, rebuttable presumptions that can be rebutted. So, for example, if the recorder malfunctioned, the police officer can testify the recorder malfunctioned. And if the last 20 times they came into court with a recorded interrogation, you would think Of course, the recorder probably did malfunction this one time. So allaying police anxieties, in this digital age, there's no excuse for not recording. It's very inexpensive, unobtrusive, and can be stored easily, unlike, say, even just 10 years ago.
Can I ask a clarification on your response? You indicated that, and it makes a lot of sense to me, that a higher level of scrutiny may be appropriate if there is no videotaping of the interrogation. But how do you scrutinize a confession where there's no record of what happened in advance of it?
Well, it depends on what you mean by scrutinize. In the pretrial reliability hearing context, we're not looking at what caused the person to confess, whether it was threats, promises, lengthy interrogation, whatever. The focus would solely be on the reliability of the confession. And if you don't have a record of what occurred during the interrogation, you still might have other evidence in the case, albeit, it might be contaminated evidence, might be imperfect evidence, but things from which you can make inferences about whether the confession bears indicia of reliability or not. Did the person explain anomalies that only the true perpetrator would know? Did they lead them to missing or new evidence? Did they say things in the confession that were contradicted by the case facts? Was there physical evidence left at the crime scene that matched or didn't match them? Were there things that would have had to have been logically true that were not confessed? The opposite was mentioned in the confession, right? So you could look at things within the confession, absent a record, that suggest the confession is highly inaccurate. The problem is you're going to have a mix of accurate and inaccurate statements in most confessions. And the prosecution is going to be saying, but wait a minute, they got this fact right and that fact right. And the video recording would show that contamination and say this is why they got it right. But you could still do it in the absence of a recording. I'm not sure you could do it as well, and it may be you can't do it effectively enough to even make the recommendation absent video recording, full video recording. Kim.
Richard, you've already talked about people confessing, and the sort of the standard. I confess to a crime, and I tell you something that only the police know, which is better, but you could still suffer from either overt or unintended investigator leakage of information. The final is telling the police something they don't know that they can then go out and confirm, like the location of a gun. Has anyone ever done any studies of the forms of the questions? And I'm specifically referring here to, if you're familiar with the Austin Yogurt Shop murders, yes. When you looked at the interviews there, a lot of questions were posed, like, not what did you do? It was, did you go in the front door or the back door? Guess what? Half the time, they got those questions correct. And the ones they didn't get correct, they would just circle around, make it clear they were incorrect, and then ask the question again later. So, yeah, they actually got a lot of things right, but it had to do with how the questions were structured, sort of dichotomous. Has anyone ever studied that?
I think there's universal agreement that the question shouldn't imply the correct answers, and people have studied that in the context of other studies, but I'm not aware, as I think here, about a specific study of the form of questions in cases leading to false confessions. This would be something that would be ripe for criminological study. One of the things that is really great about the phenomenon of contamination that I did not mention, that Peter's always the first to point out when he talks about the problem of contamination, is that the law enforcement manuals, law enforcement training materials are quick to say, hold back non-public facts, don't ask questions in ways, particularly in the post-admission portion, that feed or suggest the correct answer. And so when you look at contamination, those three errors that I talked about. When you look at misclassification, the police and the academic community disagree. They'll say, no, we really can tell better than you're giving us credit, and your studies are stupid because they don't involve high stakes but of course they do sometimes. And then on coercion, they say, police will say, if you put a gun to their head or threaten them with the death penalty, that's coercive. And we say, no, there's lots of more subtle ways to coerce. So we disagree with them there too. But on contamination, we're in agreement. The police say, do not contaminate. It's a bad practice. They are very, very emphatic in their manuals, all of which is to say, I can't think of a specific study, though the issue has come up in many studies, but this would be something where if you wanted to study this in cooperation with police, I would think they would be far less threatened because they have a vested interest in verifying their confessions through non-contaminated information, right, through holdback and improving the practice whereby contamination occurs. It's really funny in a way. They are threatened. Their identity is threatened. I know you're a former police officer. I don't mean to suggest this in a critical of police so much as empirical. That they seem to me in America, you weren't in America, to be threatened by this whole idea of coercion, when you say they're coercive, and often threatened by this idea that they're not good at discriminating between who's lying and who's not, right? And they have to make lots of discriminations on the street, and they typically begin on the street before they become detectives. But they're not threatened by contamination, right? So you can have a cooperative conversation with them. And this is an area that really deserves more study. Jennifer Mnookin, a law professor at UCLA, has done a lot of forensic work, was on that forensic commission, the National Academy in 2009. She thinks that police contamination is just as present in true confessions as in false confessions. It's purely a hypothesis, don't know if it's true, but we need criminologists sort of studying this and studying the form of the questions and how this plays out. So I hope somebody at Simon Fraser University will do this or anything related to what I've spoken to, and I would be happy to be an outside member on that or those dissertation committees.